Welcome, everyone, to our program this afternoon. My name is Michael Moreland. I'm the director of the McCullen Center here at Villanova University's Charles Widger School of Law. As many of you have been to some of our programs before, but some of you, I hope, are here for the first time. The McCullen Center is here at Villanova to try to bring a true diversity of views to our campus and provide a distinctive space for faculty and students across college boundaries to discuss issues related to constitutional liberty, especially the First Amendment, economic freedom, the place of religion in civil society, and civil discourse. We've hosted prominent judges, including Justices Samuel Alito and Justice Amy Coney Barrett. We've hosted notable religious leaders such as Rowan Williams, the former Archbishop of Canterbury, public intellectuals such as Ross Douthat of the New York Times and today's guest, leading scholars of the law, including Akhil Amar, and public figures such as former Vice President Mike Pence and former South Carolina Governor Nikki Haley. Just a quick announcement of our next event 2 weeks from today, 2 weeks I think, right? On Monday, April 7th at 4 p.m., same place exactly, we will host Adam Kirsch, who's a writer, literary critic, public intellectual, for a discussion of his recent book on settler colonialism, ideology, violence, and justice, and the ways in which settler colonialism has been used in some potentially unjust ways. And so that will be a program 2 weeks from today with Adam Kirsch and our chair in Jewish law here, Chaim Seyman. They'll have a similar kind of format, a fireside chat discussion. Thank you to the many people who've helped to bring about this event, especially Melanie Dudley, the Assistant Director and Program Manager for the McCullen Center, and the many administrative support, development, IT, facilities, and communications staff who are always so generous in helping us put on these programs. Quick logistical note, for those seeking CLE credit, you can drop off your forms at the table where you probably registered on your way in. And after this event at around 5 o'clock or so, we'll have a reception in the student lounge, which is just around the corner, a few yards away. And we have free copies of Yuval Levin.
Somebody paid for them.
Well, yeah, they were paid for, but they're free to you, so that you can have one of Yuval's books, and if you ask nicely, perhaps he'll sign it for you. So with that, Yuval Levin is one of America's leading public intellectuals. He is the director of the Social, Cultural, and Constitutional Studies program at the American Enterprise Institute, where he holds the Beth and Ravenel Curry Chair in Public Policy. He is the founder and editor of National Affairs. He is a senior editor at the New Atlantis, a contributing editor at National Review, and a contributing opinion writer at the New York Times. At AEI, Dr. Levin and scholars in his program research division study the foundations of self-government and the future of law, regulation, and constitutionalism. They also explore the state of American social, political, and civic life, focusing on the preconditions necessary for family, community, and country to flourish. He served as a member of the White House domestic policy staff under President George W. Bush, where we first met 20 years ago. He was also executive director of the President's Council on Bioethics and a congressional staffer at the member, committee, and leadership levels. In addition to being frequently interviewed on radio and television, he has contributed essays and articles in numerous publications, including the Wall Street Journal, the Washington Post, the Atlantic, and Commentary. He is the author of several books on political theory and public policy. Most recently, the book we're discussing today, American Covenant, How the Constitution Unified Our Nation and Could Again. He holds an MA and a PhD from the Committee on Social Thought at the University of Chicago. Please join me in welcoming to Villanova, Yuval Levin. So we initially had scheduled this program in October.
Yes, that would have been different.
Before the election, and the book is about the Constitution and national unity, and so it was just a few weeks before the election. We had to reschedule that. We had the election. The country's unified and happy.
That's right. All is well.
And so there's no really reason to have this program anymore, but we'll forge ahead anyway. Well, just open-endedly, what is this book about? What's the thesis, and what are you trying to argue for?
Yeah, well, thank you very much. First of all, thank you for having me here. And it's wonderful to be in conversation with my old friend. This book is a reintroduction to the American Constitution from the vantage point of a divided society in need of unity. And it begins from the premise that the Constitution is really intended to address such a society, that the framers understood American society as inherently diverse and divided, even in their time in the 18th century, and that the system they devised is actually distinctly well-suited, in comparison to even many contemporary democracies, distinctly well-suited to helping a divided society hold together and address its differences, even though it doesn't always feel that way, because it often puts us at loggerheads and forces us to confront people we don't agree with. That very fact is how the Constitution holds us together. It doesn't allow narrow majorities in society to use their narrow majority status to exercise unrestrained power over minorities, which the parliamentary democracies often do. Instead, the American Constitution always forces factions in society into negotiation and competition and dealing with each other, literally making deals with each other. It forces us to confront the reality of the existence of people we disagree with. And if we understand that this is one of its fundamental purposes, we could see some ways toward improving the system to better serve us today. But at the center of the book is really the notion that unity, as it's understood by the Constitution and as it ought to be understood by any free society, unity doesn't mean thinking alike. Unity means acting together. And very often acting together when we don't think alike, because we won't think alike. The Constitution begins from the premise that we won't. And so the idea of unity that's often prevalent in our politics, when politicians talk about unity, usually what they mean is, if everybody agreed with me, it would all be much better. And I agree with that. If everybody agreed with me, I think things would be great. But we shouldn't actually expect that to happen. And the Constitution does not expect that to happen. It assumes that our society will always be the scene of intense disagreement and begins from there to think about how that society could work. And so I think in this moment, the Constitution is the solution, not the problem. We should not look at it as the source of our divisions, but as a potential way forward, and that to the extent that it is failing us, which is a very great extent in this moment, it is because we have fallen away from the practice of constitutionalism rooted in the document and its premises. And the book tries to help the reader see what that might look like in the 21st century.
So I have a series of questions that came to me as I was reading through this book, which I think is just fantastic, and I hope everyone will get a copy and get it signed and go home and read it. So I'll pose some of those and then open it up for some audience questions toward the end. But just on that last point you make, Yuval, it is true, right, that right now, both on the progressive left and on a certain accounting of the right, the Constitution is attacked. It's viewed as either, anti-democratic or tainted by our history or insufficiently this or that. What's behind those criticisms, and how do you think they can best be answered?
It certainly is true. I would say the most intense political combatants on all sides now are very, very frustrated with the Constitution. And they're right to be frustrated, because the Constitution refuses to allow the most intense political combatants on any side to win. Instead, it forces them into a process of negotiation with the rest of the society. And particularly in periods of narrow majorities, the Constitution is therefore very frustrating, because what happens is you win just barely and you think, well, okay, we won, so now we get to do what we want. And the Constitution says, no, actually, you got to deal with those people. And every recent president has found himself sitting in the Oval Office thinking, why am I dealing with these people? I just won the election. And the Constitution wants to say, well, they won too. And winning narrowly isn't going to be enough. I think it's really important for us to recognize, in looking at American public life in the 21st century, what's distinct about our time is not polarization, right? We've had a two-party system almost from the beginning in American life, and when you have two parties, they're polarized against each other, sometimes more, sometimes less. What's distinct about our time is deadlock. We have lived through now a 30-year period of 50-50 in American public life. That's very unusual. If you look in on American political life, at almost any moment, you would find a majority party holding together a very, very messy coalition, and a minority party trying to build its own coalition, make it broader, and become a majority. Both those parties are engaged in coalition building. Since about the end of the 1990s, we've lived in a politics of two minority parties. Each defines itself entirely against the other. Its argument to the public is not, here's what we can offer you, but if those guys win, the sky will fall. That's all either party says to the public. And it's not focused on broadening its majority, but on turning out its most intense supporters, which is, as a political matter, roughly the opposite of broadening its majority. And so our politics has been stuck in a dynamic that doesn't allow for coalition building, which is really the essential skill of American constitutionalism. I think a lot of the reason for that has to do with our falling away from the practice of constitutionalism. You see it most of all in Congress, an institution built for coalition building, which now operates as though it's a European Parliament built to provide a narrow majority for the president. And the failure to think about how do we broaden the coalition, how do we get people to vote for us who aren't sure about us. Neither party's asking that question. Each party's asking, how do we get our people to turn out even more next time? And what happens is you win a tiny majority, you pretend it's a huge, dramatic, epoch-making win, and you proceed as though you have all the power. On the other hand, you lose by a tiny amount, and you think, well, that was so narrow, we're just going to do the same thing next time, and it'll work next time. And it does work next time. And over, the two parties have found themselves in a place where they don't feel like they need to do the hard work of building coalitions. I think coming to know our Constitution better would show us that we do need to, that you can't really achieve much in our system without a broad coalition. And to see that now would require a kind of reacquaintance with the Constitution.
Mm-hmm. About Congress, you have chapters on the various institutions of the Constitution. About Congress, though, and this harkens back to some of your other work as well, it's a broken institution in your view. Why is it broken, and what are the possible fixes?
Yeah. You know, in talking about Congress, I have to start with an embarrassing admission, which is that I actually really love Congress. I'm that one person at the edge of the poll that says this is a great institution. But I don't think that it's doing well now. I think Congress is dysfunctional in a very profound way, and in fact that the breakdown of Congress is the source of our constitutional trouble in the 21st century. We're going to spend a lot of the next 4 years talking a lot about presidential power and the courts, because there are going to be these titanic battles between the president and the courts. But we have to see that oftentimes the source of our trouble is what we don't have enough of, not what we have too much of. We do have too much presidential power. We do have too much judicial power in many instances, but that's because we don't have enough congressional power. Congress is underperforming in a very fundamental way, and it is the reason why our recent presidents have been so hyperactive. It's the reason why the courts are called on constantly to do the crazy things they're called on to do, because Congress is not doing its job. But I think you'd get a lot of agreement now if you say Congress is dysfunctional. I actually think there's some disagreement about what function Congress is not performing. The natural answer to that question is it's not passing big bills. So the big problems we have, however you define those, our fiscal problems or immigration or the environment, wherever you think, Congress is not passing major legislation to address these problems. That's true. But I think that the underlying problem is that Congress isn't doing the job assigned to it in the Constitution, which is to say Congress is not facilitating cross-partisan bargaining and accommodation. Now, that's why we're not passing big bills. But to see that that's the underlying problem is important, because if you think the problem is just we're not passing major legislation, then you think the solution would be Congress needs to be more efficient, centralize power and leadership, let them move bills more effectively, get rid of the filibuster, everything that slows things down. If you think the problem is Congress is not facilitating bargaining across lines of difference, you actually want Congress to be less efficient. You want members to have to deal with each other. You want to decentralize power from leaders, so it's not just 4 people making all the decisions, but you have the opportunity to create some peculiar coalitions in Congress. You love the filibuster, as I do, because it's the only reason we've had any bipartisan legislation in the last 20 years. And it's also prevented a lot of very bad ideas, both left and right. So it really matters how we think Congress is broken. And I think what Congress is fundamentally not able to do is facilitate the kind of deal-making that's required for durable policy progress in American politics. And in the absence of that, everything is left up to the president, and presidents cannot serve that role. We end up with a kind of lurching back and forth with every new administration. Every president in the 21st century spent half his time undoing his predecessor's executive actions, and then the other half taking actions that his successor is going to undo, and nothing happens. It feels like a lot's going on. I mean, right now it feels like a lot's going on. What's going on is you're creating a to-do list for the next Democratic president for what to undo, and that is not going to endure. So I think we have to see that ultimately durable policy change requires Congress to do its job, and unless we see what that job is, it's going to be very hard to do.
I listened to a podcast you did a few weeks ago with Ezra Klein from the New York Times, and you made a point during that, following up on something you just said, that, and this didn't start with President Trump to be sure, but that presidents are increasingly taking on a kind of legislative role. They're through the executive orders, through the administrative agencies, and that the system is not designed for that.
I think you can paint a bigger picture in that sense too. Because Congress is not functioning, we've had each of the institutions kind of move over one seat in the system. So presidents play a legislative role. They think their job is to advance a policy agenda on behalf of the party that won the election. That's a description of Congress's job. Meanwhile, Congress is acting like the courts. Its fundamental work is basically oversight now. They think their job is to review the actions of the president and either to take action in response or to stand on the side and cheer. That's a little bit more like the job of the judiciary. And the courts now are called on to act in real time, to keep the plane from taking off. That's apparently the job of the courts. Well, that's actually much more like the job of the president. If you think about the way the institutions work, the separation of powers is not just about taking this thing called power and dividing it into three. The institutions are different, and they play different parts for a reason. You can think about these in this kind of chronological way. So Congress is future-oriented. It frames legal frameworks under which we will live in the future. The courts are past-oriented. They review past actions to see that they were in line with those legal frameworks and with the Constitution. The president operates in the present tense. He's the person who gets the 3 a.m. phone call. He has to decide now, what is the American government going to do? Again, within those frameworks. The other institutions are not built to do one another's job. The courts cannot act in real time. I mean, we're learning that now. They are not very good at make a decision by this afternoon. That's what the executive branch is for. And the president is really not built to take this kind of forward-looking policy-making role. That's Congress's job. Congress is really not constructed to review past actions and decide who did the right thing and who did the wrong thing. We have to think about the role of the institutions each in their own terms. And again, I think in large part to begin with, because of the dysfunction of Congress, we've pushed each institution into another's role, and it creates tremendous problems. Everybody now is doing a job they're not well suited for, and shows.
So one of the points you make early on, almost every page has an insight, but one of the early points you make is about how the Constitution dealt with these apparent antinomies or alternatives and often took a yes-both approach. So liberalism or republicanism, is the president a glorified clerk or is he a head of state? Is Congress a representative institution or is it representative of the states? Should you say more about that argument of yours?
Yeah, I mean, when you look at the Constitutional Convention, at the way in which the Constitution was framed, a lot of the way things took shape was deal making. Differences were resolved by a kind of bargaining and negotiation, but a lot of the deepest differences were not resolved at all. They were contained within the system in a way that allowed them to continue to be the kind of organizing principles of American political life. And so one of the biggest questions that the framers faced was essentially whether They were creating a confederation of states in which the states would be the essential forms of government, and the national government would just resolve problems that were common to them all, or whether they were creating a new national government that would govern the people directly. And the answer they gave was, yes, we're going to do both of these things at the same time, even though they contradict each other. And American federalism, in essence, says we have both a confederation and a national government. We separate the domains of action between them, but they both operate at the same time. Or will the large states or the small states be more powerful in Congress? The answer is just yes. They're both going to be powerful. We have two houses of Congress built on two different premises of the logic of representation. The job of the president is the same way. I think it's important to see that problems are resolved in this way because it actually provides our system with an extraordinary source of balance in difficult times. It's possible for the American constitutional system to shift its weight without falling over, to lean more in the direction of a president who is a head of state at certain times and a president who is just an administrator at other times, to lean more in the direction of state power at some times, national power at other times, within the framework provided to us in the system. There's a lot of give in that system. There's a lot of leeway. And some of the questions we face, and sometimes you see this in difficult Supreme Court cases, there actually just isn't a single answer in the Constitution. There is room to lean in one direction or another at different times. It can be very frustrating if you just want to know what's the original meaning here. And sometimes the original meaning really is a kind of balance, a kind of back and forth that allows our system to answer the same question in different ways at different times. I think it's one of the strengths of the American system, but it also is obviously a source of frustration for us.
Just a particular question, which I know you've talked about in other forums as well, but again, if we'd had this a few weeks before the election, it would have been a very hot topic, but it's still a hot topic. Why are you a defender of the Electoral College?
Yeah, it somehow matters less. It matters less, and I'll tell you, it matters less because it matters most in very, very close elections, and especially in ones where, of course, the popular vote and the electoral vote point in different directions. And we've seen that happen twice in the 21st century, very controversial in both cases. The Electoral College, I mean, there's no point pretending that the Electoral College is some kind of brilliant scheme cooked up precisely to resolve the problem of selecting the president. The Electoral College was a compromise, a very, very messy compromise, and it's never really worked in quite the way it was intended. The idea was that the electors would actually meet and confer and discuss and deliberate over the choice of the president, and that never happened. Not even in the very first presidential elections did that happen, and certainly after the 12th Amendment, when the structure of the Electoral College was changed, the Electoral College has been a rubber stamp on the outcome of state elections since then. That's in 1804. It's a long time ago. Nonetheless, I think when you think about political reform, you have to ask yourself, compared to what? And if our choice is the Electoral College compared to what is generally offered as an alternative to it, which is a single national popular vote, I do think we're actually better served, significantly better served by the Electoral College than we would be by a single popular national vote. For a number of reasons. It allows the regional distinctions of the American system to be represented in the selection of the president. It allows, in a sense, the same electorate that chooses the Congress to choose the president, because the way in which the Electoral College works is that every state's Electoral College delegation is simply the size of its congressional delegation. And that means that the same complicated principle of representation, with 2 senators to each state and then a number of representatives based on its population, is also how we choose the president. I also think that it means that our national politics has to care about some of the smaller states. If we simply had a single popular vote election, it would be decided in New York and California. That's how control of the House is decided. It's kind of an ironic thing, we don't think of it this way, but who controls the House when things are close, as they have been now since the 1990s, is actually determined mostly in New York and California. And Republicans control the House when they can win a few more seats in New York and California than they normally would. The rest of the country is basically predetermined, and the other states just wouldn't be big enough to matter. You'd have an election where each party focuses on its strongest, largest states, and a lot of the country would be left behind and rendered unimportant. Instead, what happens is our elections are focused in those states that are most contested, right? Those states that could plausibly go either way. And that means that our presidential elections are focused on voters who could plausibly go either way, rather than getting the very last Democrat out in California and every last Republican in the Southeast. It doesn't matter how many Democrats you get out in California. If you didn't win Michigan and Georgia, you didn't win the election. And those are states where you have to talk to the middle of the country. So on the whole, I do think that we are ultimately better served by the Electoral College and in general by the decentralized character of our election system than we would be by one election where a very close election would present us with a very, very daunting problem. Our elections have been very close. This last election was very close. Donald Trump got 49.8% of the vote. Kamala Harris got 48.3% of the vote. It's so close that if we just had a popular vote, we probably would have had to have a recount on a national level, which is not what you want in a nation of 300 million people. And so I think we have to think practically about some of these questions, and it does seem to me that we have a reasonably good system given the complexity of what we're trying to do.
Of course, we're in a law school here, and so we're interested in judges and courts and the role of the judiciary. And this is a quote from page 230, just get you to reflect on kind of the deeper currents of this argument. You say, neither progressive judicial activism, think the Warren Court, things like that, nor conservative originalism has focused enough on the question of constitutional structure, and the contemporary battles between them risk taking an excessively assertive judicial role for granted. The next phase of judicial evolution in our system must emphasize the judge's obligation to police these structural boundaries that make republicanism possible.
Yeah, so this is really, I would say if you read this book, you'll note that it is a book about the structure of the Constitution, or about what we might say is the structural Constitution, much more than it is about what we normally talk about when we talk about constitutionalism, which is the range of protected rights that are created or suggested by the American Constitution. A lot of the hottest battles in the courts from the very beginning have tended to be about rights, about the Bill of Rights, about the 14th Amendment, about various emanations and penumbras from those that end up creating the arrangement of rights that describe the constraints on the American government. Some of this is because of a certain kind of progressive judicial activism, which used the logic of the 14th Amendment in particular to create rights that I think are not in the Constitution and are not intended by it, and give the courts enormous power to change the structure of American constitutional practice. And in response, a lot of that is a function of the fact that the conservative judicial movement, conservative legal movement, arose in opposition to that progressivism. And so also is very much about rights, but in the opposite direction. It tries to suggest that judge-created rights are the biggest problems in our constitutional system, and has set out for itself a very long-term project, which is now well along to being achieved, of rolling back some of those progressive inventions of rights. That battle matters a lot, but I think what it leaves to the side is the first and foremost role of the courts, which is to enforce the boundaries of our constitutional structure, to make sure that everyone in the system, majorities and public officials and the institutions, are doing their proper work in the American constitutional system. An emphasis on structure, I think, is now what we need more than anything. For all the reasons that we've already gotten to, the way in which the three branches' work has been deformed requires, I think, a real push back toward the logic of the Constitution, and that requires real effort by the judges. It makes me think of Federalist 78, where Alexander Hamilton says that in order for this system to work, it's going to require extraordinary strength of will among judges. And what he means there is not about rights. He's writing before the Bill of Rights. He's writing about a constitution that did not have any enumerated right, any articulated individual rights. What he means is the judges have to protect the structure of the Constitution. And I think a recovery of that now, move in that direction, to my mind, is, first of all, the natural extension of the conservative judicial movement, the natural next step for the Roberts Court, and also what we really need most from judges now. And you can see that now in what's emerging. The questions being forced before the courts in this new administration are questions about constitutional structure. They're questions about, can the president do this without Congress, much more than they are about individual rights and the Bill of Rights and the 14th Amendment. I think that is a sign of things to come, and that it's going to require a way of thinking from the courts that is, at the very least, an extension of the battles we've seen. And I think in some ways is going to require some new thinking that's really a recurrence to the thinking of the framers.
Maybe just a footnote question. In that quote, you talk about policing the structural boundaries that make republicanism possible, and you talk really throughout the book a lot about republicanism, not capital R Republican Party, but small r republicanism, which is a slippery term.
I managed not to define that term, I think, in the book. Yeah, republicanism is a very important concept for thinking about the American system, but it's also very, very hard to define, and it always has been. I would say even in the generation that wrote the Constitution, and they had a lot to say about republicanism, they found it very difficult to specify the meaning. In fact, there's a letter by John Adams that refers to the provision in the Constitution that says the federal government has to secure a Republican form of government for all the states. And he says, I've talked to every signer of the Constitution. I have not found one who can tell me what that is supposed to mean. And I think that challenge presents itself because republicanism captures a set of ideas that, at least for us, has now been largely overtaken by some other concepts like liberalism and democracy. A lot of what we mean by liberalism and democracy has to do with what they meant by republicanism. But what's distinct to republicanism is a sense of ownership of this society. Republicanism is about citizenship. What matters most about it is the idea that this is the society of the citizens. The problems are our problems, the powers are our powers, the system is our system. And republicanism is a way of taking responsibility for the common fate of our society. This word responsibility, it actually used to be the case that the Oxford English Dictionary said the first use of responsibility in English was in James Madison's notes on the Constitution, which was a really nice little thing to be able to say to audiences. The latest version of the Oxford English Dictionary found a use of it 40 years earlier. It's very inconvenient for me, but it's still the case that the word responsibility really comes into common use in America, not in England, and as a political term, as a way of describing the role of the citizen of a republic. And I think that can help us to see what it means. It speaks to the peculiar fact that the first word of the Constitution is the word we the people. The document speaks on behalf of a society that is taking common ownership of its own future. And that idea that that's what politics is, that when something goes wrong, we don't just stand around and fold our arms and wait for somebody else to show up and fix it, but it's our problem, is the essence of republicanism. And I think the American Constitution is built for a small r Republican people, for people who take the problems to be their own, for people who think that they're responsible for choosing those who will lead, and for taking part in leading, and for voting, and for running for office. The idea of a republic is that the most important office is not the president, it's the citizen. And I think that's something very important for us all to remember.
So the book is, I would say, a very hopeful, robust defense of the Constitution, but is also somewhat maybe pessimistic, but pessimistic about some of the diagnoses of our current ills, things that are sort of, as it were, extra-constitutional. One of them, and I could pick several at random, one is the primary system in the political party process, about which you're not a fan, because... Yeah,
well, let me say something about how you put that question, too. I am hopeful. I'm very hopeful about America. I'm not optimistic about it. I'm a conservative. I don't just expect things to go well. I think that's a silly way to be. But optimism and hope are not the same thing either, right? So I'm not a pessimist, though I'm not an optimist. Pessimism and optimism are both just ways of being passive about the future. Either you think it's all going to be great, or you think it's all going to end up poorly. Either way, it's just going to happen. I think saying you're hopeful about your own country is to say that if we are up to this, things can go a lot better. And it's ultimately up to us. The possibility for improvement is there, but it requires us to approach our politics in a mode of reform, a way of thinking about how do we fix this problem. That's very much how I think about party primaries. Party primaries, parties in general are not really envisioned in the Constitution. The Constitution was written in a very peculiar moment in American political life when it was possible for very serious people to imagine that we might have a politics without parties. Those very same people, as soon as the system got going, created political parties because they realized that they need some way to organize collective action in politics. And parties really are essential to playing that role. So we've had parties from the beginning, but they're not envisioned in the Constitution. One of the most essential purposes they've had, and that they have in every democracy, is candidate selection, deciding who will run for office on behalf of the party. And our parties in the last half century and more now have essentially farmed out that role to what are increasingly random constituencies of voters, people who are the ones who show up on primary day. In many states, they don't even have to be members of the party to choose who the party's candidates will be. And in any case, they're a very small sliver of the electorate. Because of the way primaries work, only the most intensely devoted people will show up and vote in primaries. And what that ends up meaning is that the most intense partisans are the people who choose who runs for every office in the American system. And in this very polarized time, those people are the people who least want to see the system produce compromise and bargains and accommodations. They're the people who most want ideological purity. So we start every election cycle by asking the craziest people in America, who do you want to be in our politics? And here's what we get. We get some crazy outcomes. And I don't mean this to be offensive. I'm a primary voter. I'm crazy too. It's people who watch cable news and constantly think about politics and have a very strong opinion about which of these three people should be our nominee for this House seat. Primaries are not new. They've been used for congressional elections for almost 100 years in some parts of the country, including here in Pennsylvania. But they're a very bad fit for 21st century American political culture. We have to see that given the way in which our politics is fragmented and polarized, we need to now think differently about candidate selection within the parties. The goal of the parties is to win elections, general elections. That's what they're there to do. And the primary system is standing in their way of doing that now. They end up picking candidates who are less likely to win the general election because they're more intensely supported by the most intense partisans in the party. And over, both parties, and Republicans do this a little more than Democrats, end up choosing people who are not going to win the general election because they are better suited to the attitudes of the most intense, devoted partisans who vote in the primaries. The parties have to see this is not working. I think in general, our parties have to see that in the 21st century, they've both been losing over and over and over. We've lived in a time when control of Congress has shifted back and forth more than at any other 25-year period in our history. Control of the presidency has constantly been shifting back and forth. We've just had the third presidential election in a row when control of the White House has changed hands. That's only happened one other time at the end of the 19th century when we also had this kind of 50-50 period for a while. We've just had an election, a set of elections where a person loses the presidency, waits 4 years, runs again, and wins. That too has only happened once before in that very same moment at the end of the 19th century. It was a highly dysfunctional moment, as this one is, and it resulted in party reforms. And this one needs to result in party reforms too. Changing the ways we think about how we choose candidates for office to maximize each party's chances of putting forward appealing candidates. And it's going to be very hard to advance this change because the people who are winning under the current system are the ones who are going to have to decide to change But they do need to see that they're not really winning, that 50% plus one is not victory. You know, not in a presidential election and not in the fight for control of Congress. And I think until we see that, we're stuck in this 50-50 place, and the primaries are a big reason for that.
So one last question before I turn it over to the audience, so think of your questions now. But the book is a deep dive into political theory, constitutionalism, and history. But I suppose we've talked a little bit about the current moment, so maybe just one more question about that. A lot of discussion, front page of the New York Times and Wall Street Journal, constitutional crisis. What is a constitutional crisis? Are we in a constitutional crisis? Could we end up in a constitutional crisis?
Well, so I think one thing that stands out when you look at the structure of the Constitution, and as you say, this book is really about that. I'm not a lawyer. I'm a recovering political scientist, and so I don't think about it simply through the lens of the third branch. The Constitution is set up to create confrontation, and intense confrontation can feel like crisis. I think we do have to see the difference between intense confrontation and crisis, where to think of constitutional crisis, I think that's a situation where the structure of the system breaks down. I would say at this point, it doesn't seem to me that we are yet in a constitutional crisis, but it does seem to me that we have a president who seems to be eager for a constitutional crisis, or at least people around the president. I think one natural way in which we could end up there is if the second and third branches find themselves in a place where they're in a showdown that neither is willing to back away from. If the Supreme Court orders the president to stop something he's doing and he doesn't stop, it is not clear what is supposed to happen next. Now, I say the Supreme Court because I think what we're seeing so far is all kinds of fighting over lower court decisions where there is recourse. The administration can and has appealed. And when a lower court judge says no, there's room to push back, there's room to appeal, there's room to try again. And the question of what's supposed to happen in the meantime is actually a genuinely complicated question. I don't think that we're in a constitutional crisis at this point. But I think that if the administration pushes for a fight over impoundment of appropriated money, for example, where there's a clear congressional power to appropriate funds, if the president decides just not to spend the money, and the courts say, actually, you have to spend the money, and the administration doesn't do it, what's step four? I don't think we really know. And it does seem like there are at least people in the administration at senior levels who want to see that fight happen, who want to break the boundaries of executive power. I have to tell you that I'm mystified by that. I don't see any reason for a fight over impoundment when your own party controls both houses of Congress. There's no excuse for that. It's never happened. They keep saying, well, impoundment used to happen all the time. Yeah, look at when it's happened. The big impoundment fights were in the 1970s when Republicans controlled the White House for extended periods. Richard Nixon won 49 states in the Electoral College in 1972, and then got into a big fight with Congress about what he wanted and what they wanted. The Congress was dominated by Democrats for 40 years, from 1954 to 94, and so the battles between the branches were the battles between the parties. I guess I can imagine an excuse for an impoundment fight in that situation. What exactly is the excuse now? What is Congress not willing to fund that the president wants to do or to take away? The law allows the president to send Congress a rescissions bill, saying, I don't want to spend these things. Congress can then pass that by a simple majority in both houses. You can't filibuster a rescission bill. So there's Republican majorities. If Elon Musk wants to spend less on something, the president can send a rescission bill to Congress. Congress can pass it. There's no reason, no excuse for a confrontation over impoundment. We're approaching that place because the administration seems to want it. And I think that is inviting a constitutional crisis. I hope it doesn't come.
Well, I promised to leave some time for questions, so especially if we have any students, I want to be sure they have a chance to ask any questions. But I do see a hand in the back. Go ahead, sir.
Thank you. Very thoughtful. So to the extent you think that the judiciary's job today is to put the branches back in their proper boxes and get Congress reconnected to the tradition from Magna Carta, the Glorious Revolution, to actually making laws, to get the executive back sort of executing. Do you believe that it's time for the judiciary to put the administrative state, which exists in what, Article 1.5, to put it back subordinate to the political branches and get it under control again in a way that leaves it responsive to the people who you indicated are the primary subjects of this whole system?
Yeah, absolutely. I think this is actually something that's very important to see in the way in which this court is likely to approach the separation of powers. We're going to see a lot of confrontation over executive power, and in looking at those fights, it's worth keeping in mind a kind of rule of thumb about executive power that I would put this way. I think that it's worth our seeing that the president is in charge of the executive branch, but the executive branch is not in charge of our government. No one is simply in charge of our government. The branches share that power. So if the question is, can the president do this in the executive branch, the answer is likely to be yes. Can the president fire that guy? Can the president let that 21-year-old idiot run the Treasury computer system? Yes, very likely. The president probably can do that. Unless the law very specifically says he can't, it's very likely that he can. And a lot of the fights we're seeing are going to go the administration's way. But when the question is, can the president ignore a congressional enactment, the answer is very likely to be no. I think this court is maximalist on both of those points. It's going to insist that the executive branch is accountable to the president, and this gets to your question, because I think the idea that there are independent agencies that are executive agencies but are not accountable to the president is not long for this world. It's an idea that does not belong in our system, and I think we are beginning to see it getting rolled back. It's going to be pushed back in part by the administration and in part by the courts. This Supreme Court, I think, tends to share the vision that the executive is one singular branch, and it is ultimately accountable to the president. And administrative agencies, if they are genuinely administrative, have to be accountable to our chief administrator, to the President of the United States. That doesn't mean that the president gets to legislate. It doesn't mean that the president gets to ignore congressional legislation. But it does mean that we don't have agencies that just float around and are not in any of the three branches. And so I do think we're going to see that kind of change in the structure of the administrative state advance in the next few years. You've begun to see it already. There have been efforts to bring the regulatory process of the independent agencies into the OMB control, the OMB regulatory review process, so that when they make rules, they have to be accountable to the president's priorities. I think that's the right way this ought to work. There are going to be some hard questions in that process, because some agencies really aren't quite executive. I think the Federal Reserve, for example, is actually much more of a legislative agency than an executive agency. It's exercising a fundamentally legislative power over monetary policy, and it's going to have to be decided. You can see, in fact, in the executive order that President Trump signed a few weeks ago, bringing the administrative agencies under OMB control, he specifically excluded the Federal Reserve. And I think that's the right thing to do, but it creates some open questions that the courts are going to have to be resolving over the next few years. Broadly speaking, though, I do think that we're likely to end up in a system that has essentially three branches again. And the idea that there are agencies that are outside of those branches, accountable to no one, it doesn't belong in our system, and hopefully isn't too long for this world.
Julie Klein, yep.
Thanks for a very interesting talk. I'd like to know more about your diagnosis of Congress's disempowerment. How did it come to be that what would appear to be a very powerful branch of government, after all, with control of the purse, would essentially abdicate or find itself sidelined? There might be complicated motivations for that. Right now, for example, as you say, the Trump administration could go to Congress, but it certainly looks like Congress does not want them to do that, and doesn't want to go on the record for some things. So I'd like to know more about kind of your analysis of this situation.
Yeah, thank you. I think this is the question that James Madison would ask if he were around today. Madison assumed that Congress would always be the strongest branch in our system, and in fact worried that it would be too strong. The willful disempowerment, self-disempowerment of Congress is really the central political dynamic, constitutional dynamic of our time. And I think it's been driven by a number of factors, but it is important to see that it's willful, as you say. Members don't want the responsibility, for the most part. They're not asking for it, they're not demanding it. Part of the story has to do with a kind of gradual replacement of the separation of powers by the separation of parties. Members understand their political interests as defined by the strength of their political party more than by the strength of their institution. I think we've also gone through a very long period without divided government. Every new president since Bill Clinton, so the last 30 years, has come in with his party controlling both houses of Congress. Now, in almost every case, they've then lost at least one of those houses, and we've had a kind of interregnum of divided government. But that's not enough for Congress to recover its sense of its own power, because every few years a new president is elected with both houses of Congress. And so in that moment of greatest momentum, when the presidency is strongest, which is in those first few months of a new presidency, the president has had Congress on his side every time for more than a generation. And Congress has gradually lost the sense of being protective of its own prerogatives in a way that's distinct from partisan interests. I also think that the complexity, the nature of modern government has tended to make the work of administration more important to voters in many cases than the work of legislation. And we've come to a place where we look to the president to resolve big problems, and so Congress plays the same role and says, what are you going to do about it, rather than what are we going to do about it. But I think that the intense and centralized partisanship of the institution is the key part of this story. Centralization of power, which began really in a way in Congress in the 1970s, it's a long story, but you have a large class of progressive Democrats elected in 1974 who confronted a huge obstacle in Congress that came from within their own party. All the committee chairmen were Southern Democrats. A lot of the new members were Northern Democrats, and they had to get around the chairman to do things on civil rights, on various things they cared about. And so they pushed power to the Speaker, who was on their side in the House, and that began a long process of pushing power to the Speaker. The committees grew weaker, the leadership grew stronger. That was then vastly accelerated by Republicans 20 years later, after the 1994 election, when Republicans came in and wanted to push hard against Bill Clinton, and they decided we're going to centralize power in the Speaker and let him be our prime minister, fighting against the president. The results of that have been very, very bad for Congress, and have created a situation where most members don't really have the opportunity to build the habits of legislators, because their everyday work in the committees just doesn't matter. The big decisions get made by leadership, at midnight before a government shutdown. And so Congress is out of the practice, out of the habit of functioning as a legislature. I think it will take a lot of work to get to a place where the institution thinks about itself as the central actor again. A lot of education and a kind of socialization of ideas among members and staff, which is part of what my team at AI is trying to do these days. But it is a long-term project. Congress is very far from thinking about itself in this way now. And a lot of that has to do with partisanship. I'll tell you a quick story, and maybe it's a story you remember too, Mike. Just to highlight that this is not a new problem. In 2006, in the summer of 2006, there was a bill moving through Congress that would have reversed George W. Bush's policy on funding stem cell research. And the president had said he would veto that bill. So the bill was moving, it was going to pass. I worked at the White House then, as Michael did. And we had a quick meeting with the president just to confirm that he, in fact, meant to veto the bill, like he said. It was 15 minutes in the Oval Office. And he said, yeah, I said I'd veto the bill. I'm going to veto the bill. And everybody gets up to leave. Easiest meeting ever. And then the president says, what do we actually do to veto a bill? This is 2006. He'd been president for 5 years. And I have to say, I didn't know either. But it was going to be his first veto. He had gone through an entire presidential term and more without vetoing any legislation. And the reason was Republicans controlled Congress for his entire first term. And they never sent him any bill he didn't approve of. So that already by that time, Congress thought of itself as, in essence, secondary to the president's agenda. And the measure of the effectiveness of a congressional majority is, are we serving the interest of the president of our party? That is simply the wrong way to think about the nature of Congress, but it's how a lot of members themselves now think about the institution.